Welcome, everybody. And today's spotlight is very specific because we are delighted to have our lovely Jemma Forrest back from Anderson Strathearn. And you are here today, Jemma, to educate us all on the Employment Rights Bill, which has been creating a lot of noise in the HR community and actually the wider community as well. Any business leader needs to be aware of these changes that are going to be coming into play. So, firstly, thank you for coming back. My first question, and I'm just going to kick off straight away with the obvious question, which really is, there are so many changes coming our way, and it would be impossible for you to go through every single one. So you have kindly said that you're going to cover the kind of the key headlines that people need to be aware of. So what are the biggest changes that you envisage with the Employment Rights Bill that HR leaders, business leaders need to be aware of?
Yes. So thank you first of all for having me back, Katie. It's lovely to be here. So yes, as you said, a huge suite of changes are coming in with the Employment Rights Bill. I won't be able to cover them all.
I know.
There's far too many. But we'll try to do what we can in the time we've got to cover some of the main changes. So there are significant changes coming to unfair dismissal rights. There's going to be changes to third-party harassment,
Yep.
family-related rights, significant changes to 0 hours and low hour workers, and also some aspects around trade union engagement. So I'll try and touch on those on the session today. So first of all, unfair dismissal rights. Unfair dismissal is one of the biggest changes that we're going to see with the Employment Rights Bill. Currently, we have a 2-year qualifying period, meaning that an employee must have 2 years of continuous service before they can raise an unfair dismissal claim, unless they're going to rely on an automatic ground for dismissal.
Okay.
So the change that the bill is bringing in is that they will have a day one right, as long as they've actually started work. So the bill envisages what they call this initial period of employment, which the government is also calling a probationary period. So we're seeing that being used interchangeably.
Mm-hmm.
What they mean in the initial period of employment is that there will be a light touch approach to dismissals. So I put that in kind of inverted commas, as the government is saying there'll be a light touch approach, but we don't yet really know what that light touch approach is going to look like.
Okay.
There is a next steps document that sits behind the Employment Rights Bill, which sets out that they expect the light touch approach to be set out in further regulations. And they expect that to be, for example, holding a meeting with the employee to explain the concerns, where the employees can be represented if they want to be. But there seems to be no reference to a right of appeal at this point in time. So during that initial period of employment, which we think will be 9 months, that's the government's preference, but that's something to still be decided. The dismissal, where the principal reason is conduct, capability, statutory restriction, or some other substantial reason, the light touch approach can apply. So one of these reasons relating to the employee means that the employer can use the light touch approach. The right, as we see it, only extends to employees. It doesn't extend to workers, but we know the government does still want to consult on a single status of worker, so that might be something that changes at some point in the future. What is quite standout is that redundancy isn't on that list. So we think that if you're being dismissed on grounds of redundancy, regardless of how long your length of service is, there would still be that fair process to follow under the current legislation and the Employment Rights Act.
Okay.
So, and we think that's because redundancy is not an employee-related reason, it's a business-related reason. So we think that's perhaps why there's that different approach. So the right as well only applies to employees. So I suppose at one point we were thinking, would there be a right for workers to claim unfair dismissal? But at this stage, it's a right relating to employees. But the government does still intend to consult on a single status of worker. So that's something that we might see in the future. So that's the key change for unfair dismissal. As I mentioned, third-party harassment is going to change as well. So prior to October 2013, there was a potential liability for employers for third-party harassment.
Yeah.
We don't currently have an explicit protection for harassment by third parties, except we did have a change on the 26th of October 2024, which brought with it the new positive duty for employers to take reasonable steps to prevent sexual harassment of their employees in the course of employment. So that's wide enough in its definition that it could extend to third parties. But that positive duty only relates to sexual harassment. It doesn't extend to other protected characteristics. So the intention would be to change that so that the employer is not allowed to permit a third party to harass an employee of theirs. And if it happens in the course of employment and they fail to take all reasonable steps to prevent that harassment, then there's a potential direct liability for an employer. So a fairly significant change, particularly for those that have employees, facing the public day to day and what they do.
Yeah.
So we'll see that come in with the bill, and also they're intending to change the positive duty that I referenced there. So as I said, the positive duty is to take reasonable steps to prevent sexual harassment, and they're intending to change that as a positive duty to take all reasonable steps. So a slightly higher threshold, and there's some debate about what the difference is, but essentially a higher threshold there for employers to fulfill.
Okay. I mean, there's lots here, Gemma. Good grief, lots for employers to be mindful of. So what other areas do we need to be aware of?
So I touched on start flexible working. So since April this year, there's been a day one right to make a flexible working request. And there's always been 8 statutory grounds to refuse a request. So the employer has to rely on one or more of those 8 statutory grounds for the test to be satisfied. There isn't a question of reasonableness in that. As long as they rely on one of those grounds, then the test is satisfied. So what the bill intends to do is make 2 changes. So first of all, they would say that it has to be reasonable for the employer to refuse the request for the change. So essentially meaning the employee can argue, well, that was unreasonable to rely on that reason. And secondly, there has to be an explanation for the reason. So more than just saying it's the statutory ground and quoting what that is, they need to set out a justification. And so there is a bit more of an onus on an organisation to set out why it is that they can't make that change. But crucially, the changes, those 8 grounds, those haven't changed. So those 8 reasons are the same.
Okay, well, that's some good news, I guess.
Yeah, some consistency in what's happening and what's been in place so far. So for family related leave, there's going to be day one rights for paternity leave and unpaid parental leave as well. Currently, there's a service requirement for each of those, and the current protection for parental bereavement leave is going to be extended. So not just to parents who lose a child under the age of 18, there's going to be a wider entitlement to unpaid bereavement leave to a wider group of people, although we're yet to find out who that wider group of people is.
That'll be really not contentious, isn't the right word. There is a lot of conversations about bereavement leave, what classifies as bereavement, when should people be allowed to grieve, etc. So I will watch that with interest, and it's interesting that the government aren't being kind of clearly defined in what that bracket is, or what those kind of categories are.
Yeah, and businesses will have their own policies on compassionate leave and who that extends to. And I think it is quite difficult to draw a line as to who it would extend to, because it's not necessarily family members that will be the closest people to, that somebody would want to take time off for. So we'll watch this space and see what happens in terms of how that group is defined.
Definitely.
There's also going to be some protection extended to pregnant and new mothers beyond coming back from work. So we'll see some changes in that field. And then some significant changes to 0 hours and low hour workers. So they will have the right to a guaranteed hours contract if they're a 0 hours or a low hours contract. So on a particular number of hours a week. We don't yet know what the cutoff threshold would be to be considered to be a low hours contractor. But essentially, if you're a 0 hours contract or a low hours contract, then the organisation is obliged to offer you a guaranteed hours contract that reflects the number of hours worked in the previous reference period, and then guarantees that minimum number going forward. So essentially then guaranteeing pay as a result. We expect the reference period is 12 weeks. The next steps document talks about that. So looking back at the previous 12 weeks to see what the average hours have been and the number of hours worked in that period. and then looking forward as to how we would then offer the guaranteed hours in the future.
Sure.
It's then for the employee or the worker, should I say, to accept or reject the offer. They don't need to. And it could be reviewed again if obviously they accept the revised contract and then they continue to work more hours than are set out in this minimum hours contract. So we may see that changing. There's also some changes to the right to reasonable notice of being required to work a shift for 0 hours and minimum hours contracts, and the right to reasonable notice of a shift cancellation and the right to be paid. So again, we don't know what the notice period for each of those looks like, but we expect there to be some clarity on that in course.